I'm Jesse Morris. I'm Josh Kaizuka's sidekick.
No, I'm the sidekick.
Yeah. What we're going to do is we're going to go through just briefly some of the terminology for criminal law, mostly to give you an introduction. But as a practical matter, when you write the articles, you're probably not going to use a lot of the jargon that's going to be here because your readers may not know it. So you'd be probably talking in plain language in your articles, but this is helpful to you because if you're in court, you might be hearing these words, and then you'll have an understanding what's taking place in court, even though you may not be using those words in your articles. Josh?
It's probably a good idea to just have a basic idea of what the process is in court. So when you show up to court, you kind of know what the particular hearing's about. Terms like, suppression motion, 1538, 995s. In California, in criminal court, you're going to hear lots of numbers. And so just understanding that you're going to hear those things and have basic idea of what kind of motions or terms are used relating to motions might be helpful. So that's kind of going to be the focus of what we're going to be doing today, hopefully without taking up too much time.
So if you look at the screen just above us, Josh has put together just a brief introduction for our little talk.
So we're going to start out with when things go bad. And I'm assuming everybody knows who these two characters are. You ready for this touch screen?
Will the defendants rise? Considering all the facts and arguments presented by both counsel, and after careful deliberation, I find the defendants guilty as charged. Do you wish to waive the right to a pre-sentence hearing? No.
Yes, Your Honor.
Taking into account the severe and ruthless nature of this crime and the bleak prospects for your rehabilitation, I hereby sentence you to serve 125 years in the custody of the Commissioner of the Department of Corrections.
Wait, no, sit. We didn't do it. There's a misunderstanding.
That's
we
right.
didn't do it.
We didn't. I didn't.
Our lawyer told
didn't.
us to come up. He's joking. He means
I
we
told
didn't do
him.
it.
See,
we didn't do it.
Have you got the right case?
This is Monroe and Donahue.
Harry Monroe. Harry Monroe. Look under there. Look
Sir.
under that. And black, tall.
Sir, we didn't.
Black man.
How much does that mean in actual time?
30 years tops.
I'm gonna be a dead old man.
So it's interesting, you're talking about how much am I actually really going to do. We'll get to that later. So this is kind of the basic criminal process that you're probably going to see. And there's a difference in what happens or time limits between misdemeanors and felonies. Do you want to kind of go over what the basic differences in misdemeanors and felonies?
On misdemeanors, it basically means that somebody can't be sentenced to state prison, but on felonies, it's state prison. And we're talking about the potential sentence or the maximum. And as far as an arrest, if somebody is committing a crime and it's a misdemeanor only type of crime, then the crime has to be committed in front of the arresting officer, which means the arresting officer has to be a witness to the crime. I'm just like disturbing the peace, somebody playing something too loud. And how they usually make the arrest on a misdemeanor is usually by citizen's arrest because somebody else sees the crime taking place. And so you end up with a citizen's arrest. Why don't you talk to us about a felony, Josh?
So felony is very different. The crime doesn't have to appear or the officer doesn't have to witness the arrest. He can do it on investigation, and if he comes up with probable cause that a felony has been committed, then he can arrest the person, go ask a judge to make the call by submitting an affidavit, Sometimes you'll hear the term Ramey warrant. I don't know if we heard that too much in Yolo County, but basically in other counties you'll hear the term Ramey quite often. It's basically another way to get a judge to sign off on an arrest warrant. And basically, he just says, hey, I've got probable cause to believe that somebody committed a felony, judge signs off on it, then the cop can go and arrest the person.
But as far as a misdemeanor is concerned, most of the time somebody just gets a ticket, much like a speeding ticket. So if somebody is jaywalking, somebody's disturbing the peace, somebody now, because of Proposition 47, most drug possessions that are misdemeanors for simple possession, they can simply be just given a citation, promised to appear, and show up in court. On felonies, typically they're arrested and have to post bail. Misdemeanors, they can be taken into custody also. You'll find that mostly common if somebody's committing a misdemeanor and a domestic violence misdemeanor. And because they want to separate the boyfriend, girlfriend, husband, and wife, put them in custody so that you don't have a reoccurrence. So it's sometimes discretionary with the officer what happens. Josh, what about a felony?
Well, felonies, in most cases, somebody gets arrested on a felony, they're taken down to jail, they go through the booking process, and in most cases, that individual is going to have to post bail. Now, each county has a different bail schedule. Some counties, you'll hear the term stack the bail. I don't know if YOLO stacks bail. I don't think they do. But what that means is if the person's charged with multiple charges, for example, let's say a domestic violence incident, they're charged with a 273.5, which is corporal infliction or infliction of corporal injuries on a spouse or cohabitant, and then let's say they add kidnapping, and then they add something else, all arising out of the same charge. Many counties, they'll set the bail, the jail will set the bail at the charge that has the highest bail amount. Other counties, and it happens very often in like San Joaquin, it happens in El Dorado County, they'll take the bail amount for each charge that the person's arrested for. So, for example, in Sacramento County, a domestic violence case, typically the bail's set at $50,000. Okay, it doesn't change, it doesn't go up or down. The jail just basically says it's $50,000. So if you get busted for the same thing with multiple counts in, let's say, San Joaquin, you could end up with a $150,000 bail, whereas in another county, it'd be $50,000. Then you go to court, whether you're in custody or you posted bail. One thing that you might hear in felony cases, if you're covering drug charges, you may hear something to the effect that there's a hold, and they're going to throw out some numbers at you, but basically what it is they want somebody to show that if they're going to post bail, that money that they're going to use to post bail comes from a legitimate source, not from the sales or illegal activities.
If we move on to arraignment, arraignment is the term for the first court appearance. And at the first court appearance, they're told what the charges are. They're arranged to have an attorney appear for them if they hired one, or have the public defender appointed if they cannot afford one. And in most situations, that's the time when a bail is set. If sometimes they're arrested without a bail at all. As Josh told you, in the majority of cases, bail comes off of whatever is on the county bail schedule. They're in court usually within 72 hours on a felony, 48 hours on a misdemeanor, and we're usually talking court days. So the secret is don't get arrested on a Friday, okay?
Or Thursday. Thursday's even worse.
That's right. Okay. And so once you have an arraignment, in most counties, they enter a plea, for example, of not guilty, Or let's assume no plea is entered because the person says they don't want to enter a plea. The judge can enter a plea for them of not guilty, and then the case moves forward. On a felony, a preliminary hearing is set within 10 court days of the not guilty plea. And if it's a misdemeanor, 30 days for if they're in custody, and 45 days if they're out of custody on a misdemeanor. Josh?
Just a couple things. So at an arraignment, not only can you ask for a different bail to be set, the DA's office can ask for the bail to be set higher. Or in some cases, you can ask the judge to be released on OR. Sometimes you see in court, they make this decision right on the spot, but that's not the way the statute reads. Typically, you have 2 days in which to come back to court and have a hearing on whether you should be released on OR or get a bail reduction.
Sometimes you hear the term grand jury being bandied about when you talk about criminal cases. That's normally very rare in Yolo County. It's common if a preliminary hearing is difficult to arrange. For example, in Sacramento, they have Folsom Prison. To move somebody from Folsom Prison to court may by itself be dangerous, depending on the nature of the defendant that's charged. And they think that everybody's always plotting to escape, and they know that because you've seen all the movies where they do that when they're transporting them, right? So they do a grand jury indictment instead. So a grand jury is assembled. They listen to the evidence much like a judge at a preliminary hearing, and then come back with something that's called an indictment. So the indictment is then the initial charging document for a felony case, and there is no preliminary hearing, and it goes straight to the jury trial after that if there's no time waiver within 60 days. In Yolo County, that's rare. It comes up from time to time in what I've seen political cases of some sort, and I think some sort of high county official, but it's been rare for me to see a indictment in Yolo County.
Now, we were talking about time limits. The time limits for trial and preliminary hearings. In Yolo County, typically at arraignment, somebody's going to enter a not guilty plea. Other counties, for example, Sacramento, at the arraignment, there's no plea entered, so that the time clock does not start. And it gives, depending on how much time you want, it gives both sides some time to look at the stuff before kicking in your right to either a speedy trial in misdemeanor cases or a preliminary hearing in felony cases. In effect, even though in Yolo County or other counties where there's a plea entered at arraignment, it's not too often that cases actually go to a preliminary hearing in 10 court days. Maybe in 60 calendar days, but 10 court days. Even when I was a public defender, we set them, but for it to actually go to preliminary hearing in 10 days, especially on a serious case, it doesn't happen too often. Even in misdemeanors, I think in the thousands of cases I think I've handled or touched when I was a public defender in Yolo County, if there's a police report and there's a real issue of whether or not that person was lawful, that person actually committed a crime, if the person's in custody, you have a right to what's called a 991 hearing. And a judge can look at the police report and say, well, based on looking at this police report, I don't see that a crime occurred. I think I only used that maybe about 2 or 3 times in the entire time I was there. But I have used it, and only when somebody's in custody. I guess we can go on to the next. So, continuing with the basic criminal process. So we saw the video where, Gene Wilder and his buddy got convicted. Like Jesse said earlier, in misdemeanors, there's maximums that people can be put into jail. And they're broken in misdemeanors that are either 90 days or now in California 364 days instead of 365 days. Does anybody here know why? Immigration consequences. So the state legislature changed the punishment on misdemeanors from 365 days to 364 days to avoid immigration consequences for sentences that are 1 year. So you can't be technically in California on a misdemeanor be sentenced to a misdemeanor for 1 year. It's 364 days.
Or 364 days is defined by statute as 1 year. If a judge says 1 year, it's automatically 364. So it avoids a particular penalty consequence on immigration cases for anybody that is not a citizen or has immigration issues. Defendants can usually, on a misdemeanor, get immediately sentenced because you have an idea what the sentence is going to be anyway, and it's usually agreed upon between the attorneys and the court. But you're entitled to have a delay. But the delays mostly become more important when you get to the felony cases, when you start talking about the inability to know what the sentence is going to be. For example, if you go through a jury trial or you go on a plea and there's certain issues that are still not determined. So there's 20 days, that's 20 court days from a conviction or a plea to the time of sentencing in a felony case. You're entitled to, I forget now, 5 days delay on the misdemeanor, or up to, I can't remember how many hours. But anyway, you're entitled to a delay in a misdemeanor case. So just in case you walked in and you parked your car outside and suddenly you learn that you're going to go into custody, you're entitled to a delay in that sentencing. Up there they have appeals. Appeals in a misdemeanor case goes to a Superior Court Appellate Department, and appeal in a felony case goes to what they call the Third District Court of Appeals. Most people never think of a trial court as having an appellate department within its own department. So you're in basically Superior Court, you go to trial, and you get convicted in Superior Court, and then you appeal, you're still in the Superior Court when hearing that appeal. And everybody says that's not fair because the guy's just passing judgment on their own buddies. Okay, but they get to do that because of a consolidation in the court process that came about a while back. In felonies, they go up to the Third District Court of Appeals, for example, here in Yolo County, Sacramento, and the surrounding counties. The sentences that are up there on the screen, this is alternative sentencings. Those are concepts where the jail, it's like somebody sentenced to jail, and then they sentenced to like a work program. People have heard that. Or they're sentenced to ankle monitoring, which is electronic monitoring, in-court home arrest. Those are matters that they think of as a jail without walls. And so the sheriff controls the jail. So the judge can't say, I sentence you 5 days in cell number 1 and 5 days in cell number 2. The judge didn't get to do that. That's an executive decision, of executive branch of government versus a judicial branch of government. And you can't have a judicial branch of government making executive branch of government decisions. So the sheriff controls where the person does the time. That means that if the judge says, the work program is authorized, but the sheriff refuses to put the person on the work program, the judge can't put that person on the work program. All right? That's an executive branch of government decision, not a judicial branch of government. So they always say the work programs recommended or electronic monitoring is recommended. They don't sentence the person to those. They have other things that are diversion programs, and that comes up in a situation where you have somebody developmentally disabled. You have drug programs where someone can go to the program and they avoid either the conviction and sometimes the jail. I probably should have studied the handout a little bit longer, kind of skipping.
It's okay. I can go backwards.
And so you have these what they call specialty courts, and some of them are statutory, where the court really has no discretion except the person that go into them. A lot of them are discretionary in terms of the court individually creating those programs locally and made their own criteria as to whether or not somebody gets into them. Josh, why don't you cover those things that I may have skipped over?
So, I think going back to the jail stuff, Jesse's absolutely right. The sheriffs really have the ultimate say, or whatever the custodial executive is for that county, typically the sheriff, on whether the person gets relief from actually having to do jail or doing some sort of alternative, such as home detention or some sort of work program. There's certain types of charges that if you get a conviction, some counties say it has to be done in custody. For example, in Sacramento County on DUIs, they literally take the statute portion that says on a second DUI they have to spend 96 hours in jail, as they have to spend that time in actual custody, as opposed to being able to do the 10-day statutory minimum all on work project or home detention. Yolo County typically lets anybody apply for alternative sentencing on DUIs, and in most cases, unless there's a prison sentence. Other counties, like Placer County on a standard DUI, if it's a second or more, they'll want somebody to do at least half of that time in custody. El Dorado County is different. If you get a third DUI, they probably want you to do all of it in custody unless you enter their DUI diversion, DUI some sort of program where it's really intense. And so, like Jesse said, each county is different. There may be alternatives to doing things in custody or not in custody. Did you want to go over 1170H?
No, but let me just pick up one thing about those programs. A work program or electronic monitoring, the sheriff charges for those programs. Mm-hmm. And so part of the problem is many clients are indigent, they have no money, a lot of them are homeless. And so that they can't get into the program, even though sometimes the statute says that the sheriff is supposed to be able to provide a lot of those programs for free or at discounts. They can't get them because you end up with this the executive decision making that, even though they're poor, they're not poor enough, and then they still don't get it. You will find on some occasions where they say, look, I can't afford the program, I'm going into custody. Mm-hmm. They go into custody to do, let's say, their 15 days. Sometimes counties charge them for being in custody. They will get a bill, $125 a day from being in custody. I'm seeing some head shakes, so you've heard that in court. And so it's a penalty for being poor that's being levied, and that's some of the issues that are taking place right now in terms of controversies on the criminalization of the poor within our county for going through the criminal justice program. Now, in court, you may hear some people talk about, is this 1170H case? Is it not 1170H case? 1170H is a penal code section, and the subdivision H came about primarily because there was an overcrowding in state prisons. And the concept became that if someone is a non-violent felon that's committed to state prison, Maybe they should not serve their time in state prison because it's overcrowded. Maybe they should serve their time in the county jail. However, they're serving state prison time in the county jail, but it will still count as if they had a state prison sentence. One thought is that if somebody commits a crime in a particular community, that if they serve their time in the community leaders will understand that they're going to get out at some point, so they should give them some sort of education and training and social services so they don't get into a particular type of trouble when they get out, as opposed to the primary theory of they've committed a crime, they have to be warehoused, let's get them out of the community, and they toss them into prison. So they think that the local community is no longer responsible. So this is placing responsibility back into the local community for making sure that that person receives some sort of rehabilitation services, or at least support services when they get out, as opposed to just kicked out the door and suddenly find themselves homeless and probably stealing or doing something illegal to make money and support themselves. But anyway, 1170H basically means they serve their time in the county jail versus going to state prison. And then there's twists on that as relates to the probation department supervising them after the supposed state prison sentence, even though it counts as a state prison sentence. So those people with strikes, for example, will still go to state prison. There are certain designated crimes, such as domestic violence crimes, driving under influence crimes, evading arrest crimes, that will still go to state prison. All right. Other non-violent crimes usually are in county jail. Now, you'll hear the term split sentence. Split sentence is a term I think they borrow mostly from federal court, where you end up with somebody, let's say the maximum prison sentence is 3 years. Now usually if somebody before 1178 got a 3-year sentence, they go to state prison maximum 3 years, and then they would have a parole time afterwards. Now if the maximum is 3 years, then that is the maximum, and that has to be served in county jail. Then the total jurisdiction that the court has for sentencing is 3 years. That means they split the sentence between county jail and probation, all right, or mandatory supervision. And so what happens is, if they get, let's say, a 6-month sentence, then the balance of the 3 years, 2.5 years, can be on supervision. If they're violated, they can be sentenced all the way up to the maximum of 3 years. Okay? In the so-called old days, if they got violated, they could be sentenced to a term longer than the 3 years because that's the parole term. Now the 3 years is the maximum control time for jurisdiction. So ever how it's split between the 3 years, that's going to be agreed upon as to the time in custody, and then how much time they're going to be supervised on what we typically talk about as far as probation. And then time credits. If something's a strike, and they certain violent felonies, they serve 85% of the time. Rapes, robberies, murders, I mean, no time, I guess, is a life sentence. Okay, on terms good. But the others, the most common felony, they serve 50% of the time. Okay? Now, if they have a prior strike and they've gotten out of prison, then and they charge the prior strike, that doubles the time on the present offense, but they serve 80% of the sentence instead of 85% of the sentence. So let's say somebody had an auto theft. They no longer get so-called 1170H, which means serve it locally because of the strike. So the strike tosses them into state prison, and it doubles the time. So the maximum, let's say, was 3 years. Now it's 6 years because of the strike, but they serve 80% of that time. If they never had a strike, they would do, let's say, maximum of 3 years split. Let's say 1 year in a county jail, and then 2 years on supervision. All right? What happens is sentencing and sometimes victim impact statements?
Well, I was just going to kind of go over the
Oh, okay.
diversion, and
All right.
because everybody know what diversion really is. So there's different kinds of diversions.
Rehabilitation type thing.
No, it's even better than that. So like it's typically for first-time offenders. Like let's say somebody shoplifts, never been in trouble before. Typically in most counties, they have a program where you take a one-day class, basically some sort of theft class, and then the case gets dismissed so long as you don't get into trouble during a 3 or 6 month period of time and you do the class. For first-time offenders relating to drug use or possession of drugs, typically there's something called PC 1000. I don't know if you've heard. No, drug
No?
court's a little different. It is a form of drug court, but PC 1000 is basically for first-time offenders. Minimum is 18 months. If you do everything you're supposed to, stay out of trouble, no new crimes, it's almost like getting your record wiped clean of that drug offense, even including the arrest. There's some small twists here and there. Drug court, and I used to get this mixed up myself, is typically for people who it's not the first time they've gone through this before, and it's a last chance effort. Instead of going into prison, you do a very intensive program so that you can stay out of prison. Now, I don't think that happens much anymore because of 1170H. Most possession charges are misdemeanors, and people aren't going to go through this long, convoluted thing to not go to prison because prison's probably not hanging over their head. Mental health court, I'm not sure if YOLO has that. Do you know, David?
I don't believe so.
Okay, so in other counties, for example, Sacramento, they have a mental health court. And it's for individuals who have mental health issues that contribute or is the cause of their criminal behavior or conduct. Could be theft-related, vandalism, drugs, assaults, you name it. There's a whole gamut of things that kind of fall under this. Now, if they're amenable to treatment and they're accepted into the program, it's kind of intense. They have to go to counseling, they have to use services, they have to come to court, depending on what it is, every other week. And if they're doing well, then it spaces out a little bit more. But if they're successful, and the minimum in Sacramento, it's a year. If you do well, you take your meds, you stay on track, you don't relapse into whatever, you can get your case, the plea withdrawn, set aside, and the case dismissed. So there's those kind of things. And Veterans Court is similar to that. It's for veterans who exhibit PTSD primarily. And you know what? I've seen cases, even DUIs, go through Veterans Court. And if you successfully complete Veterans Court on that charge, it's wiped clean. Basically, the plea's withdrawn, the case is dismissed pursuant to, I can't remember what the penal code section is, but it goes so far as to even make the individual able to say on licensing applications that they don't have a conviction or had a conviction. So Veterans Court's actually a very nice cleanup for veterans. I don't think, does YOLO have it?
I don't know.
I don't know that I've heard it before.
What do you mean by licensing application?
So if you want to become a lawyer,
Okay.
a doctor,
So, all that stuff.
nurse, that kind of stuff. Okay. I think Jesse was talking about victim impact statements, and I'm sure if you've covered stuff in Yolo County and gone into court on a case where there's a victim, sex case, assault case, whatever, a victim is entitled to come to court and make a statement. If it's young children, parents get to come in. If it's somebody who was killed, relatives get to come in. And the judge is supposed to consider those kind of statements as well as other factors on determining what the sentence is. common motions. So this is probably the kind of stuff that you're hearing in court. You hear discovery motions all the time. Discovery, it's pursuant to Penal Code Section 1050 et sec.
1050 is continuance.
Oh, what was it? I just did a 1050 motion, that's why.
Discovery motions, what usually happens, police reports are called discovery, okay? I mean, that's the term that attorneys use. And anything that the prosecutor has to produce as it relates to information about the crime, that's called discovery. It's statutory now in terms of they're supposed to automatically turn a lot of that stuff over. But sometimes either it doesn't because, there's a tape recording, I guess they don't use tape recording, CDs now, and there are other things that are still floating around, and that has been turned over. So the defense has to say, look, I need that recording. I need the in-car camera, for example. I need the radio tapes or the logs. And so those aren't usually typically turned over automatically, but once a request is made, they have to be turned over. If the district attorney doesn't want to turn something over, then you have to file a motion of your defense counsel. There are a lot of things that may require third parties to bring things to court because the district attorney or law enforcement doesn't have them, so the defense has to subpoena them. The person may not wish to have the items turned over, and so you're litigating what they call discovery. All right, so these are discovery motions, and there's various types that Josh has listed. Now, you use snitch motions. This is a motion to disclose a confidential informant. The officers are keeping something secret as it relates to a witness, and they don't want to disclose who that witness is. Many times it's on drug cases. The pitches motion is also a type of discovery motion. This is where, for example, law enforcement officers have conducted excessive force, different types of misconduct, and you want to get their personnel records that contains this. So this is a pitches motion. Pitches was the sheriff in Los Angeles, and this was how that particular discovery motion was named, because that was in a reported case where it created the procedure for saying that you can obtain that information, and later on they codified that into a statute. The motions to quash and traverse warrant and the suppression motion, they're sort of a combination of the two. A motion to suppress means that there's something illegal that took place and you want to exclude that evidence. Most of the time it's an illegal search, all right? And so it's called 1538.5, which is the code section that comes out of. Now, what happens if the search comes out of a search warrant and then the search warrant is sealed? And in terms of the declaration, then nobody knows why the search warrant was issued in the first place. It probably has got a snitch in the background someplace, right? And so you want to get the declaration unsealed, which is a type of discovery motion, and then once it's unsealed, you want to suppress the evidence through traverse or quash or a suppression motion. And so all of these things become interactive in one way or the other, which still leaves the speedy trial, 995, and in limine. Josh?
So speedy trial motions come in two different types. So one is, they're both exercising your right to have a trial within certain time periods. And they come up in a couple different contexts. I think in most cases you hear it in misdemeanor court is if somebody gets arrested in 1999 and maybe in 2020, they go, oh, you know what? You have a case. And they arrest the person. Well, all these years have gone by. And it's an extreme example, but really only a year needs to go by when a speedy trial violation may be occurring. So the burden is placed on the cops to say, well, why didn't you go pick this person up back when the person either A, failed to come to court, or 2, when the misdemeanor happened? I see it a lot on DUI cases, where somebody got arrested for DUI, got booked, and then disappeared. Didn't either come to court. Another example is, I just had one. So this guy gets arrested on a misdemeanor, given a citation for vandalism that occurred on UC Davis property. Well, it turns out that an attorney showed up in Yolo County on that date and nothing had been filed. 3 years later, his car gets broken into. He calls the cops in a different county, and the cops say, you know, if I had known that you had a warrant, I would have probably arrested you 2 days ago, but the cop was nice enough to let him know there's a warrant. So I get the phone call. It turns out that I called the Yolo DA's office, I call the Yolo Sheriff's Department, I call UC Davis Police, nobody knows anything about it. So I call the cop who said, you have a warrant. Well, that department runs it, and it's actually in Solano County because the UC Davis property where he was cited was actually in Solano County. So 3 years had gone by, and interestingly enough, in Solano County, I show up for arraignment, they say we're dismissing for speedy trial violation because the guy never got notice.
That seems fair, though, right?
Yeah, it makes sense. For example, if you're in an automobile accident and then you're in a hospital, by the time the officers investigate it, a month, 2 months, who knows how long's gone by, and then they decide to issue some sort of citation for an arrest. You never get it.
You have no idea.
And then, time goes by before you find out that anything's there. You may have lost witnesses, who knows what, all right?
How do you defend yourself? So that's a theory on misdemeanors. There's the 1 year is typically a thing. Felonies are a little different. You have to show actual prejudice, like you actually lost something. Like, for example, a check case or something. The person's around, they issue a warrant, but they never go and arrest the person. Turns out they never even really looked for the person. 4 years down the road, witnesses are dead, bank doesn't have records. What's the person to do? Felony cases, that's the pre-arraignment delay. The other speedy trial motion is you're already in court, you've been arraigned, and you're exercising your right to have a speedy trial. And as we may or may not have talked about earlier, if you're in custody of misdemeanor cases, it's 30 days. If you're out of custody, it's 45 days. Felonies, 60 days. And so if for some reason, and a great example is when I was a public defender in Yolo County, we decided there's too many bad deals in misdemeanor land. And so basically we started setting every case, whether they're in or out, without a time waiver. Basically exercising each defendant's right to have a speedy trial in misdemeanor court. Bottom line is there's no way for the courts to be ready to go ahead with court trials on that many cases. DAs really weren't ready to go to trial on those kind of cases, and so all of a sudden you either started getting cases dismissed because there were no courtrooms, judges, DAs weren't ready, they didn't provide discovery for whatever reason. And also the deals started getting better. So that's the other kind of speedy trial violation. You're just not getting your right to a quick trial like you requested and accorded by the statute.
The problem that comes up in speedy trial has more to do with the fact that the defendant wants a speedy trial because a person wants to get out of custody quickly. They can't get a speedy trial, not because of anything other than the case is not ready. So it may take a certain amount of time for the defense to send out an investigator to find witnesses. But many times, and I think if you've been in court, you'll hear the defense attorneys complain that they didn't get a particular report or document or whatever from the prosecutor. The prosecutors had the report all the way from the beginning of the case. And so even to read the report, they'd have to waive time. Okay, that means give up their speedy trial rights for the purpose of just getting the report, contacting the witness, and so forth. All right, and so the speedy trial time ends up being given up by default by the defense because of what the defense characterizes as prosecutorial intentional delay, which is a prosecutorial misconduct. But the prosecutor says, I mean, they're giving it as quickly as they can. This is just the difficulty of processing whatever the information is. So you end up hearing those, I'm seeing heads nod, discussions in court as to whether or not that's good faith or bad faith with respect to giving the information or hiding the information or just deliberately slowing down the information. It was quite common for me to suddenly get a ton of reports like a couple of days before trial, and then the prosecutor is forcing me to ask for a time waiver, okay? Or get the reports in the middle of the trial, which is even worse. And then you try to ask for a mistrial because jeopardy is attached, and that's a bigger problem. So that when you start talking about speedy trial, you will hear that tension go back and forth in court with when you got the discovery and whether or not somebody waives time. On the time waivers, it becomes a problem. On a felony, if somebody has 10 days from the time to enter a not guilty plea to the preliminary hearing, if they waive time, then the next point is 60 days. So that's 60 calendar days. And then if they waive the 10 days, then the prosecutor has to give the any time within the next 60 days, or the end of the 60 days, the hearing. The defense can't insist they don't get their 10 days back, all right? It's just the next 60. And so you end up with these problems. And so when you end up waiving time, you'll hear them discuss how long was the time waiver, when does the clock start again, like basketball, okay?
Can't they, can't you pull back the waiver?
Sure, you can pull back the waiver, but what starts when you pull back the waiver? Okay, the 10 days doesn't start, but you still got the 60, right? And so when did the 60 start, the clock start on the 60 days? Or the next, what I call the next 60 days. All right? So that's one of the problems with speedy trials. Go ahead, Josh.
It's strategery, as George Bush might put it. It gets really confusing when we're talking time limits, especially in felony cases where you've waived time, whether it's for preliminary hearings, whether it's for the trial itself. Because if you can do no time waiver, you can do a general time waiver, you can do a specific time waiver. They all have complications. Especially if it comes down to you getting last minute discovery or you're trying to get a case dismissed because, wait a minute, you should have given this to me a long time ago. I mean, I've got a prelim right now. 2 weeks before the prelim, I get 300 pages of medical records, and then the DA puts on the case for return on subpoenaed documents, and I look at the file or the folder, and it's a pretty thick folder. I have no idea what's in there. So there's those issues.
You can do 995.
Oh. So, going back, so we've talked about a preliminary hearing, but does everybody know what a preliminary hearing is?
Like a pre-trial trial?
Yeah, that's a good way to look at it. It's kind of like a mini trial, but it's not. Yeah, it's not like a full-on press. So basically, the DAs typically put on a cop, and the cop at a prelim can basically testify to a lot of stuff. And you sit there and you've heard the word hearsay. Well, hearsay is basically an out-of-court statement that's being told in court as the truth. So a cop at a prelim can actually testify to hearsay as long as it's one layer, meaning that cop heard it. And the standard's kind of low. And so after the preliminary hearing, you might hear a judge say, well, I'm holding this person to answer because he believes that jury can find him guilty at a trial. A 995 motion is to challenge the evidence that the judge thought was sufficient for each element of the crime for that person. And when you file the motion, it doesn't go to an appellate court. It goes to another judge in the superior court. And that judge is going to sit there and look at what his or her brethren decided and either grant or deny the 995. If you do, you can file what's called a 999A to the 3rd District Court of Appeal, challenging the preliminary hearing holding order, but you have to do it within a certain period of time or you lose the ability to do that. I don't see too many 999As. I didn't see it when I was a public defender, although we did one. I remember that. And I've done them in other counties, but that's not something you hear too often that somebody's doing because, a lot of cases they probably have sufficient evidence for a holding order. Typically, 999As are filed either to cover your butt, which sometimes you do, and then other times there are real issues as to whether, first of all, the person actually committed a crime. I did one on some sort of real estate fraud case in El Dorado County once, and it actually got up to the Cal Supremes, and they basically issued a PALMA order. PALMA order is basically telling the trial court, why shouldn't we just grant this writ? So, and I think we had one in Yolo County on some sort of FTA thing. So there's different things, but you don't see those too often.
FTAs means failure to appear. Let me just expound on the 995 just for a moment. And when Josh talked about the 995 and who hears it and so forth, in law there's certain things that are talked about as presumptions and sort of rules of evidence. And presumptions have, for example, in facts versus law, which are the rules. If a court or judge makes a finding on facts, then those facts can't be impeached by somebody else reviewing it. They have to assume that those facts are true and then apply the law to the facts that lower court found. So as someone proceeds through court, let's say at the arraignment, then there's bail. He's asking for the reduction of bail. In the bail schedule, they will assume that the crime has been, in fact, been committed. The charges are true. So the person is asking for bail not with the presumption of innocence. They're actually a presumption of guilt. They committed this crime. Now let's set the bail. All right? So if you understand that concept, we now take it to the preliminary hearing. Once that judge makes a finding of fact, when they do the motion to set aside the holding order, which is the 995, they're doing it on a presumption that the facts that the court found below are in fact true. So all you're doing is challenging probably some sort of legal reasoning. So you're challenging the rules that the court has applied, saying that the rules have been misapplied in some way. Now, that's the presumptions and findings of fact, all right? And so the standard is a reasonable cause, which is a strong suspicion that crime has been committed, and this is the person that's connected to that crime. And so it doesn't take much. It's much like a qualifying round in a sports event. It doesn't mean that you're going to win the championship. It just means all of you have now put 9 people on the field, and you're of a certain age that qualifies to go on to play the game. All right, it's a very low standard, so it's a probable cause standard. And then finally, we got the in limine that Judge is going to talk about.
So, in limine, you're going to hear prior to trial. These are trial motions. Basically, you're going to file these, or you're going to hear these terms thrown about saying, a judge saying, to each side, do you have any in limine motions? And you're going to hear each side start talking about, well, I filed my motions, and they typically have to do with what they think should be excluded. There's always fights over certain types of statements to be excluded. There might be a battle over witnesses. You might hear things like, well, the defense has, they're putting on all these people and it's cumulative, and, it doesn't even make any sense because, they could do that with just one person. They don't need 15 people to come in. So those are the kind of motions that you'll hear about prior to trial if you're sitting there. Sometimes it can get kind of boring because a lot of them are standard motions. Like if you make an objection, it's federalized, meaning that you're incorporating your federal objections, not just your state objections, because unless you do that, there may be issues on appeal where somebody might say, that's a great issue, but you didn't preserve it under the, federal constitution. So federalizing is typically one of those in limine motions. Any?
No, I mean, that's basically all you're doing is setting the rules on certain parts of the trial. Sometimes the limiting motions simply say, Judge, I got an appointment on Thursday, let's break it noon and not come back for the afternoon. I mean, it doesn't have to be like really serious, but these are the rules on the procedure of making the case go quickly while the jury is there. All right. Court files. Now, this is probably where we're starting to get more practical in terms of what each of you do as reporters. A court file is a public document. You get to go in and take a look at it. However, within a court file, there's always sealed documents. So you end up with some items that are sealed. A lot of times we'll subpoena medical records that belong to somebody else. Those medical records don't become public simply because somebody subpoenaed them. So they're commonly held in the court file until the attorneys, and remember the discovery motion we talked about, argue as to whether or not they get to receive them. So they'll get to receive them out of the court file, and whether or not somebody else gets to take a look at them. It could be personnel records, okay, such as the Pitches motion for law enforcement. Now, the documents that are in a court file, if they're sealed, some of them it's possible to unseal them if you make a request to the court. For example, a probation report. Somebody has just been convicted at a jury trial. You want to see that probation report. The defense gets a copy of the probation report. The prosecutor gets a copy of the probation report. That's it. The public doesn't. The public has to ask for a copy. You have to, as a member of the public and the press, have to ask for a copy. If the defense says you can have a copy, but sometimes there's confidential information or just simply personal information in there. They don't necessarily want it to be known that they grew up in foster homes and or had drug-addicted parents or a lot of other bad personal stuff. And so those matters can be what they call redacted or removed from the probation report that you see. I mean, they're still part of the court file, but you'll see portions of it covered up. Now, the probation report after 60 days is sealed. So you need, if you're going to see it and make that request, you need to see it and make that request within that first 60 days, all right? If the clerk gives you the file, then you can make photocopies of it, but don't take anything, don't echo it. They're echoed in. Don't pull the prongs up and then take it out and then put it in the photocopy machine. You have to keep everything in the file, and sometimes you have difficulty photocopying the top part because it's bent, but you sort of have to do the best you can unless you pay whatever that fee is that the court wants, which is usually a large fee, considering that probably all you need to do is to have a copy of the document for whatever purpose, and I can't imagine you actually needing the actual copy for any news report that you're going to make. Most of the times when I see reporters with a court file, they're not even making copies. They're just writing notes down for the purpose of quoting something so they can include it in an article. What you need to do is to take a look at the complaint, because that shows you what the charges are, and orders. So you can sprinkle your article with names of the type of orders and what the court said or didn't say with respect to sentences, or what can or can't be done. What I think you're really after are the motions that are in the court file. Now, when the attorneys file something, okay, this is what the controversy is about. And as this controversy is raging, each side has an opportunity to put something in there. This is what you're looking for when you read it. Most of the time, these are allegations that are made by the prosecutor and the defense, or what they're trying to prove. For example, in a Pitchess motion, they're saying this officer has committed crimes of violence against people that have been arrested in the past, and has actually exaggerated what's been in the reports that they filed against this person. And so that's exactly identical to what's taking place in the case at hand, that my client is alleging that he didn't do these things. The officer is the one that committed the initial assault, and my client fought back. And so there is no assault on an officer, and we need the names and addresses and phone numbers of the witnesses that can establish that. That's in the officer's personnel file. So that's a Pitchess motion, a discovery motion. You now have the allegation that's there, and then you have the, let's say, the district attorney or the attorney general come in and saying, you're not entitled to whatever the reports are. All right? The same thing applies to other things, confessions, whether or not the confession is or is not coerced. And so as you litigate whatever it is within the motions, that's the controversy that probably is of the most interest to your readers. And that's probably what you need to report. Josh?
Same thing with trial briefs. Well, I guess it depends on who files trial briefs in the cases that you're covering. But, you know, if it's somebody that has a lot of trial experience, they want to kind of like position their case in front of the judge on what they should be looking for, what they believe is the controversy or the weaknesses. Trial briefs are great because it kind of spells out what the charges are, and if both sides file them, they're going to talk about what they think is their strong point, or at least they're going to pick at what they believe the other side's weaknesses are. And you're going to get a pretty fair list of expert witnesses and what they might say, depending on how thorough that trial brief is. Were they that thorough? When you
No, they really weren't.
Yeah, they were. Yeah.
At least, I mean, what happens is the defense usually, it's like you're holding your cards down. You're probably not trying to disclose that much, and the prosecutor usually files something enough to just get the case moving, but they're probably not disclosing much either. It occurred to me that you might, as you're trying to find these motions, sometimes the judge might actually have the motion because they're reading it, okay? And so it's not in the file. You go to the clerk says, hey, it's in the department, okay? And then, so you're literally running the file down. You can't take the motion from the judge simply because the judge is reading it. You got to use a little common sense, but you can ask the court clerk, what would be a good time to come back to take a look at that motion. And he says, well, I don't know when the judge is going to be through with it. He says, well, is it possible that if I come back at the end of the day, I can take a look at it at 4 o'clock, for example, all right? And so what you're doing is you're negotiating with the court clerk a time when you can have access to what basically is a public document, okay?
Except for YOLO, my understanding is they close at 3 or something.
Oh.
Yeah, now they do.
Okay, camera and voice recordings. I've often wondered why the Vanguard does not have more pictures. Now, it's not that I like pictures. Like I read the cartoons first before I read the rest of the newspaper because it has more pictures. But pictures, I think, enliven most articles. And unlike paper, print, there is less of a restriction, I think, on digital publications. And so it's probably easier to actually insert a picture in an article than it is into paper publications. And you get a whole article, there's no picture, or you get a picture and it's just the front of the courthouse. What you can do is actually file a petition to ask that you can take a picture. Okay, you don't have to have the fancy recordings like the TV stations. By the way, Josh Kaizuka, the person that's sitting right next to me, used to have this job where he would send the reporters out for this TV station to get the very things that we're talking about and to interview people. Tell them where you work, Josh.
Channel 10.
Okay. He worked at Channel 10, all right? And so you're now able to take what looks like a phone and take pictures with this phone, and you could file the form. The judge will give you the order, and you can't take a picture of the jurors, you can't take a picture of the audience, but pretty much you can take a picture of everything else. All right? So if you write your article, it'd be nice to have a picture of maybe the prosecutor, because the prosecutor will do something in your article, right? And so you can have a picture of this is the person, pointing at the defendant or who knows what. And then you can have a picture of the defendant sitting there, or the defense counsel, or the judge making the order. And so now it enlivens the article that you have. You got a digital publication through the Vanguard. Why not do that? And I think each of you that are here can start filing these petitions. And you don't even have to type it up. You can just, I've seen people come in from the Sacramento Bee and just ink in the name of the case and fill it in. It doesn't even have to be typed, all right? I mean, that's how he said. I think the standard is not to type the information on these petitions for the press. And I'm telling you that so that you don't feel embarrassed that everybody else has got this fancy petition and you don't. No, that's the way they look, all right? So start filing these petitions, take some pictures. Now, I'm not so sure anybody's going to record what takes place, much as what's taking place in terms of voice recordings. That is a little bit different. It is possible, but you can't record the jurors, you can't record the conference with attorneys, you can't record sidebars and closed sessions. So that's somewhat controversial. There are times when I think each of you have seen the jury go out and then the judge discuss in open court with the attorneys on the record something that's about to take place, like some question, and there's an objection. And so whatever that answer is, the judge now needs to put it on the record with probably maybe a witness still on the stand. Okay, so the jury doesn't know what happened. You know what happened because now it's still part of a public trial. It's just the jury doesn't know. Now, the ethics part of journalism takes place. Do you publish or not publish that? Because by publishing it, what it means is you've now published something that the jury doesn't know, and it now can infect the nature of the deliberations that take place, right? And so that's something that you have to discuss with your editor before that happens. I'm of a belief that that's not published until after, for example, it comes into evidence later, which many times those things do, so then it becomes something the jury knows, or after the verdict. But that is always in some sort of context, because many times, like in the Boston bombing case, there was a confession. They still made the objections about keeping the confession out. Everybody knew there was a confession, and so these whole pieces of the confession they're litigating. The jury's not in the room at the time, but everybody knows there's a confession. So it's pretty much public information. There's a confession. Everybody's public information. Everybody's fighting another confession. So when the newspaper's reporting, hey, this is the confession, it doesn't infect anything because everybody sort of knows it anyway. But what I'm saying is that's contextual, and you still have to make judgment calls on what is or isn't published. So that's where the editor comes in. Now, does anybody here think they're going to make a voice recording of anything? No, I didn't think so, but I'm assuming that if you walk out of the courthouse and then you put your iPhone up in front of the prosecutor and say, would you like to comment on whatever happened? I guess you can incorporate that into your digital newspaper, right? Mr. Editor? He's shaking his head yes.
Yeah.
All right.
As long as it's outside the courtroom.
How often do they approve the written request?
For cameras, it happens a lot.
So we can just get our phone. I mean, if it's approved, just at any time in court.
Yes, but you got to make sure that when you take the picture, there's no clicking, no loud noises. Okay? And the only thing that might come up is if there's more than one news agency starts showing up. The court may say, hey, you have to pool the photos, but typically the still photos, they don't care. They probably only require pooling of videos. All right? So just let the court know you just want to take a still photograph. I have only seen them denied taking a picture of a defendant if issues come up such as identification. They're not sure if this is or is not the person because the witness has not made an identification of the person that's just been arrested. Okay, so they don't want to disseminate it and infecting the witness before they make the identification in a lineup, which could possibly just simply be a photo lineup. But other than that, I've never seen one denied for just arbitrary, I don't like this newspaper, okay? You're a news agency, ask for it.
I've never seen anybody take a picture with a camera, though.
Oh yeah, they got this camera and they got this big bag around it to make it sound.
Yeah, so you got to make it look good. So whatever camera it is, it's got to look good. Like you're with a real,
No, you can't do it with your phone.
Yeah, you can do it with your phone.
Make it fancier. Attach something like,
No, these huge news agencies come in with the single lens reflexes, cameras, and then they make a lot of noise when they click. And so they got the huge soundproof bags around. You can't even see the guy's hands. They're in the bag. But
this thing has silent mode.
Does it?
Can't even hear it.
All right.
see, but it looks like a camera.
Mm-hmm.
Yeah, it surely does.
Mm-hmm. So I'm not sure where you were going with this.
Oh, okay. The next screen, it shows, I put WikiLeaks up there.
That I know.
Okay. This is probably the most controversial place where the press comes in. The press is trying to get information to the public so that because certain things are simply noteworthy and the public should know about it. At the same time, there's some sort of competing interest in keeping something secret, whether it's so-called national security or just simply just private information. So that's a journalistic call that your editor needs to make as to something does or to get published. Most of the time, if something is to be published and it's published after the trial, it probably is not a big deal. It's not going to infect the course of the trial. But if it's published before or during trial, now that timing becomes critical because it can influence the litigation. If you're doing interviews, you may want to tell whoever it is, because they don't want to talk, I'm not going to publish this until after the verdict, okay? Which could make a difference of you even getting an interview or not, all right? But the timing is important. Now, let's talk about interviewing. A lot of times, you want to interview before there's a court case, okay? So something just happened. Something, probably they just got arrested, or they haven't arrested anybody. They're looking for somebody. You're running out trying to find out what happened. So you're interviewing witnesses to the fire to find out how the fire started, or the person that found the dead body. Okay, there's a search. So you're doing a reporting by interviewing witnesses. All right. Once something is filed, now you got additional witnesses, because you got the law enforcement agencies that have conducted this investigation and made the arrest. You have the district attorney, and you got the defense. Okay. What they're about to tell you makes a difference in terms of where they are in the proceedings. The attorney probably, I got to wait for that because that's a different screen. But you can print probably anything after the verdict. Before the verdict, remember, talk to your editor. Whatever you do, okay, especially if it's before the verdict takes place, maybe sometimes even after, your contact with certain people might end up being public news by itself, okay? And you see that when you see all these stuff with respect to paparazzi, right? I mean, everybody's talking about the paparazzi because remember, I just talked to you about taking photographs. Okay, now I don't think you think of yourself as paparazzi, but I mean, in some ways you are. All right. So you're paparazzi, and so what you do, how you do it, will come into context at some point as that witness is talking to somebody else about what was just done, especially when their statements come into play in the press. They're going to start saying, and they may want to backtrack, I didn't really say that. You know how they take it out of context. They forced me to say this because they're going to, okay, whatever it is, all right? And so that's what I'm saying. Be professional, be courteous, and know that whatever your actions are, they may themselves end up being news. All right? Now, I'm going to go back.
Wrong way.
Okay. If you get a case, I've seen a lot of articles in the Vanguard where somebody looks like they're just sitting in the audience and then they're just reporting what has taken place as if they're sitting in the audience, okay? That's one way to do it. But good reporting usually is something a little bit more. There's nothing to stop you from, once that witness gets off that witness stand because they're released from the court, to just walk out and say, hi, I'm with the Vanguard. I'd like to talk to you. You just testified, and then you start asking the questions. So you can actually ask them questions about themselves, about things that they never talked about in court. They are, a resident of Davis for the last 15 years. They work at the garage. They've got a family of who knows what. Okay, and so as you do this, you're building their character, their personality, and you're now bringing that person alive, which they probably is different than what happened in court, because now the judge is trying to get that case over with, and he's trying to limit the time, and you try to just get to the evidence of what they saw. And so that now you could talk about, maybe when you saw this, what were you doing? And they could talk about how afraid they were, or how afraid, or how they felt testifying as a witness, okay? And so now you get to add things to liven up your articles, which was not available, all right, otherwise. And so you're adding context to the article you're about to write. And if I could, sometimes I'm reading articles and somebody's sitting there and the case has been going on for like 2 or 3 days. And then now they're sitting there, and now they're reporting the 4th day of whatever this court proceeding is. I read the article, and I'm coming in probably on the 4th day of that article. I don't know what happened on the earlier days. So you could say, look, this is the 4th of a series of whatever, okay? So that you as opposed to me finding out this is the first time this case is being reported, and they're actually coming in on the 4th day of that case, all right? And you got to put some context to this article that you're writing, even if you're reporting the 4th day. Because they may be like me. I'm only reading that 4th day, and I'm not reading the other stuff. And if it's interesting, I'll go back and read day 1, 2, and 3. All right? But if that 4th day doesn't catch me, okay, that's it. So, what I'm saying is, you now get to add some context to this. The fact that somebody chooses not to make a comment can also make it in your article, okay? And you've seen that in articles. And it's done, no comment. But part of it has to do with, you asked the defense for something, and they've told you, hey, this officer is beating my client and left a deep gash in their head, and they're not guilty of this offense. And then you walk up to the prosecutor and says, this is what the defense just said. Would you like to comment? They say no. Okay, so it shows that you're now not a biased reporter, just reporting something for the defense. You're now giving the other side an opportunity to comment, and they chose not to. And so you're now making your article look more even-handed. Okay, you understand how that works? Okay.
And you're going to get from probably DA's office no comment anyways. I think that's been the history. Now, I just want to caution you guys on talking to witnesses. Make sure before you go talk to them, they're actually excused.
Because they recall them all the time.
Exactly. If they're subject to recall, be very careful. Just make sure that they're excused as a witness.
Okay. This one I think is really cool, and I added it because there's a little bit of controversy as whether or not digital media counts as a news agency or news reporters. And it's only because the law sometimes lags behind reality. And so at the time that everybody had all of these rules and statutes, you always had print medium and you had TV, all right? It's only recently that this digital concept has taken place. Christian Science Monitor only publishes in digital format. They don't have newspapers like they used to, okay? But I don't think anybody's going to say that's not news. Somebody's not a news reporter when they're with that agency. What happens is that they had a paper first, and then they transitioned into that other medium, and so everybody sort of takes it for granted. But if you start with digital and you never had paper first, okay, there's always a question about it. So the question is still alive because there's no appellate case that says this, and they use the word blogger, is not a news reporter. And so Josh happens to be an attorney that represented the Vanguard and established in court what?
Well, at least in YOLO, at least in Department, what is it, 4? 6? That Vanguard is basically a news reporting agency, and that the SHIELD law applies. And I think part of this kind of comes back to some of the stuff Jesse was saying about when you publish certain types of things, you guys have to think about it. You guys all know what happened with the subpoena for David. So it comes out, it basically boils down to a publication of a statement made by someone who's going to testify in court. And so, it was a pre-publication, and basically if you report that so-and-so said this, it's not protected, that statement. Now, the reason you see a lot of agency, reports from an unnamed source is because if you put it that way, they can't get at your notes, and they can't ask you to disclose who said that. Now, it's kind of a bad way to establish credibility in a story, because do you really believe all the stories you see on Fox News about, from a confidential source, or someone over at the State Department who wished to remain anonymous because of the ongoing investigation? How reliable or how trustworthy is that? If you publish what somebody, Miss So-and-so told me or told the Vanguard, and you publish a quote, you could get subpoenaed to say, did you do an interview? Did you get a statement from this person that said this? But nothing else.
Okay. So, how does this problem come up? It doesn't come up just simply because you've now published something. It comes up because you published something that somebody else said not to publish. And the person that says not to publish, when I say not to publish, it's not, they say don't publish. It's the judge saying, for example, lawyer, I don't want you to talk to the press, okay? Now you're the lawyer and you're not supposed to talk to the press. The press now publishes something and they're saying, how did the press know that? Because nobody knew it. The press wasn't in the courtroom at the time and I told everybody not to talk about it. So lawyer, you must have talked. And the lawyer says, no, I didn't say anything. Okay, so now they want to pull in, the reporter says, did this lawyer talk to you and give you that information? Because if that happens, now they can go for contempt and sanctions against the lawyer. Okay, you see how that's working. So what happens is there is something that's taking place where you're not supposed to publish something, you're not supposed to know something, and then it comes out. And because it came out, let's say law enforcement, the court wants to know, how is it that you know? What is your source? And that's when the news reporter shield law comes into play. You look at the judge and say, I'm a law-abiding news reporter, but I'm not able to tell you that because of the news shield reporting laws. Okay? And you have that protection. Now, we talked about the gag orders, okay? This is where the judge says, don't talk to the press. And it's usually not just with lawyers, it's with witnesses, all right? And it can be certain other people that are in law enforcement. They identify somebody, so don't talk to the press. So you as the news agency representative, they don't send a gag order to you, all right? Because there's a First Amendment right you have to publish the information. Remember how WikiLeaks is in there? They can't say WikiLeaks don't publish it, okay? They can say WikiLeaks, where did you get that information? How'd you get it? Right? That's what they're trying to find out. And so there are problems when you have national security things, such as this is the ingredients to have a bomb. These are the people that have, this is where they are. And you go, I mean, they say, okay, I mean, that gets a little, where it's important, and then we maybe do something. But most of the stuff that any of you are going to run into is not going to be of that magnitude. So there are going to be gag orders. You're not part of that gag order. You find out about it. You can publish it, but you understand you've got that news reporter shield law that you're going to run into, and whether or not something was or wasn't properly stated when it was in the articles, so that it protects you, because I think all of you have read articles where news reporters are in custody. Most of those are in custody because they're federal. Federal doesn't have a shield law. So this is state. So just
You got something, but it's not like California state shield law.
Interviews at jail. You want to talk about that, Josh?
Good luck getting one. Well, that's not necessarily true. You've seen it on TV. For some reason, people just decide they just want to tell their side of the story. Once they lawyer up or they talk to a lawyer, there's probably not a lawyer around that's not going to tell them, don't talk to anybody. Don't talk to the press. Don't even talk to people in your pod about anything. Don't talk on the phone. When you have a visit from a relative, don't talk because you're recording everything. Now, we say this, but you know what happens?
No.
They do not listen, and they still.
Have the jailhouse tapes like today.
Yeah.
You can go to any of the jails to try to get an interview. Don't take your phone. Don't take a recorder. You got to take an ID. Expect that you'll be wanted or searched. If you go to prison, they really do search you pretty well over there. SAC jail, you got to go through a little metal detector thing, and then they may wand you. I don't know how often they let you take recorders in, but if you're the media and you ask nicely, they let cameras in with from TV news. So
let recorders in.
Even though you're press?
Okay.
Well, that's interesting. But anyways, it says here it's rare to get a criminal defendant's interview after the defendant's lawyer up. If that's once they talk to a lawyer. It still happens, but if you can get to somebody, if it's somebody you really want to get an interview from, you see it on TV all the time. You watch the news, Channel 3 and Channel 10, they go in and talk to these people and blah, 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 and man, it's a great story for somebody.
They usually do it right after arrest.
Yeah, as soon as before arraignment, because once they hit an arraignment, if they can't afford a lawyer, they're going to get one appointed. And, sometimes they don't tell them not to talk at that point, but, if you get to them before arraignment, that's probably the best if you want. And like Miranda warnings, you're not law enforcement, you're not the government. You're not required to let them know that they have a right to an attorney. This isn't TV. You don't have to do that.
How old do you have to be to go do this?
How old are you?
18.
You're fine.
I've never asked.
I don't know if there's
about
you got to be an
news
adult.
reporter. What it took to get in. But typically, as long as they can, you have your California's driver's license, that usually is enough.
Do you guys get press badges or identification?
No.
Thought about it?
Yeah.
I'm just saying, just so they can say it, at least they're with the Vanguard.
Usually we don't need them, so we haven't had to have them.
Well, maybe that way you can get a camera into the jail. Anyways, any questions on interviewing at the jail? Be really polite, nice, open-ended questions. If there's certain areas that you want to ask about, do it. But, me being a defense attorney, it would suck if my client was in jail and you guys got to them first. Anyways, interviewing attorneys.
Before I get to that, there are times when we have defense attorneys have press conferences with the clients there. Josh has been to those where you have certain cases that people are doing sit-ins and demonstrations, and there's a social event that is taking place, and sit-ins in the governor's office. You're holding a press conference. Your clients are. Now, interviewing attorneys. Attorneys are governed by professional rules, so it's really difficult to do an interview when the case is ongoing. They can tell you what some of the next proceedings are. They can tell you some of the things that happened in the past in terms of these are the witnesses that have testified, some of the procedures that have taken place, some of the rules rulings that have taken place by the judge, but they can't tell you pretty much what's about to happen or this is what they're trying to do. I mean, they're restricted into those things that cannot influence the outcome of the litigation. And so it probably is not going to do a lot to talk to an attorney while the litigation is taking place, but probably afterwards you can get their comments, and that's most of the times what you see on the news. All right. Now, as all of you go through, when you're looking for cases to report, and so it's those things that are current, topical, and newsworthy. Death penalty, okay, that's newsworthy because of the social impact that takes place. But almost 100% of every criminal case, you're going to find something oppressive about the fines and fees. And this is because most of the people going through are represented by the public defender's office or some sort of appointed counsel. And when you see the fines and fees being attached, the court is imposing them, not necessarily the minimum. They're not waiving some of the discretionary fines and fees. And those of you that have been in drug court or domestic violence court, you'll hear defendants come in and says, look, I showed up at the classes and I didn't have the $40 and they didn't let me stay, okay? That's something that now is a violation of probation, and they're being punished for not having the $40 to complete the court-ordered class of 52 weeks. And it happens on the drug cases also. And then they're being tossed into jail, and then they get more fines and fees. So this is being punishing somebody for being poor, not for necessarily for committing another crime.
Just to add on the oppressive fines and fees, you're going to find, if you go to traffic court, or if you go into the misdemeanor courts, it's going to be these low-level things that gives the biggest fines. For example, DUIs in Yolo County, it's about $3,100. It's one of the highest fines in Northern California for a DUI. San Joaquin used to be about $3,200. They actually are back down to about $2,300 because the fines are crazy. Another area that you're going to find high fines is driving on a suspended license. And these are going to be people who are caught up in this vicious cycle, and it starts with a stupid speeding ticket, or maybe a stop sign violation, or maybe a tail light out, or maybe a registration issue. They miss a court date, that's another $300 in fines. Then their license gets suspended, and then they can't go to work, and then they don't have any money, and then they get popped for driving on a suspended license, and this vicious cycle occurs, and you're seeing it in the news all the time. Traffic fines and low-level misdemeanors probably have the highest fines around, and people cannot swim their way out of it. I've tried to help people with fines that were in excess of $5,000 just because they were stupid fines that they didn't take care of in different counties. And each suspended license fine added another $1,300 to $1,500. A simple traffic ticket with the FTAs, which is the failure to appear, ended up costing about $1,100. It's atrocious. And like Jesse was saying, people who are ordered to do some sort of counseling or classes, for example, let's say DUI classes. How do you pay $3,100 plus another $800 for classes? Plus, if you want to do work projects instead of going to jail, pay for that, plus the insurance costs. And some people may not have sympathy for DUI people, but they can't dig themselves out. And the worst ones are people who are paying child support, or they couldn't pay some traffic ticket and their license gets suspended. They'll never dig themselves out. And I think there's legislation that Governor Brown's looking at or something to try to waive some of those things. But the good news is DMV will give back people's licenses after a certain period of time goes by. So they're not totally out of a license except for DUI suspensions. So that's definitely an area that is probably newsworthy. If you can sit there and say this person in court, just because of traffic fines, has $8,000 in fines.
Would you also find? Go ahead. I'm sorry. You were going to say something.
Do you see excessive bail being dealt with?
Oh, all the time.
Yeah, Sacramento. Really.
Well, yeah. If it's a misdemeanor, everybody in Sacramento is going to get released. Even if they, may be on probation on a felony. But if they're arrested on a felony, especially a domestic violence, it's automatically $50,000. And I've represented people where the DA's office didn't even file charges.
Which, I mean, unconstitutional, really. I mean,
It happens all the time.
Yeah.
In San Joaquin, I have some guy that was arrested on financial crimes, basically, fraud or something like that. And if it was one charge, it would be a $10,000 bail or something, but they stacked, so it's $100,000. Yeah.
And he talked, the question had to do with bail, but it reflects back to the fines again. There's a certain amount of charges and fees and as it per count. And just because a judge says the fine is $350, okay, what they don't say is that there's 175% penalty assessment on top. And so when you hear the fines, that's not the fines. There's all these penalty assessments, and it's a percentage, and it just racks up the total amount. So it's almost like you're being secretly punished, but nobody can hear it because it's never stated, okay? Because there's this assessment. It's not even it's not what the court imposes. It's just this multiplier that's in the statute.
Yeah, next time you're in one of the courts, especially misdemeanor courts, go grab one of those attachments that people have to initial that shows all the assessments, the extra costs, and you will be astounded at how much extra they're paying on top of their fines.
If you look at the computers when you're looking up charges, they'll talk about all kinds of assessments.
Yeah, so a $100 fine turns into like $500 or something.
I think 700, yeah.
Yeah, and so the maximum fine per statute on a misdemeanor is $1,000. Well, there's a lot of people paying a lot more than $1,000.
Because you're paying classification fee for the jail, okay, just for being arrested, okay,
And for the new courthouse.
and
Court funding fee.
and court library fees and the night court fees and all sorts of things. I mean, it's not that you went to night court; that the court just has a night court, so you're paying the fee. Okay, it just racks up. So I mean, when we're talking about just topics that you can look for when you're looking at the court file and know what's taking place in court. And these are controversial areas. People are tossed into custody for being poor. A lot of the cases have to do with a mental illness. Someone is trying to do what they call suicide by cop. They're trying to get the cop to kill them, right? And so they get arrested, but what happens is they don't go to a mental hospital commonly. They're actually charged with something, such as a Penal Code Section 69, which is assault on forcible violence on an officer, or Penal Code Section 148. Okay, resisting arrest. And so now they're prosecuted, and what basically is a mental illness type of act. And you're going to see that in various derivations as you go through these cases. Somebody who's just mentally ill. A lot of homeless people are picked up, and they're mentally ill. They're not placed in the mental illness type of category, such as an institution or hospital. The institution they're placed in happens to be in the jail, and they're prosecuted for it. Which brings me back to the police-initiated, what I call standalone crimes. These are crimes where it's not like they committed a bank robbery, now they're arrested and they're gone. There's no crime at all. And you're going to start seeing these Penal Code Section 148, the Penal Code Section 69s, all right? This is now the mechanism to put people in custody when there's no crime committed, and so the police are able to initiate this by making contact with whoever the citizen is, and you're rousting them, and they're in custody. For example, we just now talked about the suicide by cop, okay? This is how they get arrested and kept in the custody. And so this is the homeless person that's told to move. They're not moving fast enough. The cop is helping them along. The guy says, "Hey, why are you rousting me? You're not moving fast enough. You're delaying this, and you're not obeying my commands. Refuse to obey the command officer." They're in custody. I mean, this is the 148, the Penal Code 69. Those are the tip-offs for you as you're going through the cases, that there's these social problems that are taking place. And mental health clinics are not being sufficiently funded, which is on the other end. Officer takes them over, nothing happens to them. They may not even go into the institution. They're just let out the door, and then they're back on the street. That's frustrating to the officer. Overcharging. I hear Josh talk about that a lot. So maybe he can tell you something about that.
Well, if you've been reporting in Sacramento, you probably have heard overcharging being said by some defense attorney. What's a misdemeanor in another county or may not even be filed, if it's possible in Yolo County, it's going to be a felony. We used to litigate wobblers, which are misdemeanor, or it's a charge, it could be a misdemeanor or felony. And interestingly, in the drug arena, it was actually, if you start practicing outside of Yolo County, you'll find how crazy things were before simple possession became a misdemeanor. A scraping, probably not enough to even get you high, probably not enough to even take a puff, probably not enough to even get you a small line. In Yolo County, it would be a felony. In across the river, misdemeanor or maybe not even file, because they don't file on scrapings. If there's some sort of assault, there's no injuries. If they can do it, they'll file it as a 245 felony. Whereas across the river, maybe if they file it, it's a misdemeanor 242. Before I left Yolo County, I did maybe 4 or 5 prelims, domestic violence prelims. I think I got 2 no holding orders, which means they weren't held to answer on a felony, and then 2 or 3 reductions to misdemeanors. And that was in Yolo County. Probably across the river, it wouldn't have even been filed.
Why don't you tell them about what it means to have something reduced to misdemeanor at preliminary hearing? How's that motion work?
So that's a 17B motion. You're asking the judge, after listening to everything, to reduce the charge to a misdemeanor. And there used to be a saying when I first started in Yolo County, if you get a 17B on a DV case, it's going to be an acquittal at trial. There was one PD that probably went to a bunch of trials on reduced DV cases and basically all acquittals. That's what the reduction to misdemeanor at a prelim was. And in Yolo County, if you're a minority and you're in West Sac and you get busted for something, even if it's a misdemeanor, wouldn't be surprised if you get a gang enhancement attached so that it turns into a felony. Used to see that all the time. I don't know if it still goes on, probably does. Because all you have to do on a misdemeanor is attach a gang enhancement, turns into a felony.
And a lot more.
Yeah. Yeah, so, the DA here in Yolo County, before he became a DA, used to tout how the I-5 going through here was a corridor of drug trafficking for the entire state. And that's why, they needed this task force here.
Unit.
Well, I don't know what Unit does anymore. I think in Vanguard I read something about they were doing something silly. It wasn't really doing drug stuff. But so
Prostitution.
That's what it was.
Undercover
Yeah, undercover units.
And
gone
they're,
down.
yeah.
The stories that you could really write about how something so minimal has turned into a felony or a serious offense, something that would even exclude somebody from 1170H, where a young kid could go to prison. That's a story. There's probably plenty of them here too.
And Josh picked up the whole issue of the racial disparities that take place in the prosecution of the cases, which are starting to make news now. And I think we left it off of our little list, but it wasn't meant to be comprehensive. Electronic monitoring and eavesdropping and use of informants is something that is well hidden in law enforcement circles. It's hard to find out about them. There's the Stingray that Sacramento has, that it is of a belief that they're letting YOLO law enforcement have access to also. And the Stingray is a mechanism where it's a device that can pull in the signals from cell phones as if it was his own cell phone tower. And by doing that, they get to listen in and capture the communications that come off of cell phones.
Yeah, it's kind of crazy technology. Basically, it mimics a cell tower, so that you kind of have to go through it. And I'm not exactly sure because it's supposedly classified, but if you Google it, you'll get lots of information on Wikipedia.
And so when we talked earlier about motions to unseal warrants and things like that, these are the type of things that the attorney's trying to get to establish that there's actually eavesdropping. So when a client's house is broken into with the aid of a search warrant, like, why? Okay. It probably had something to do with electronic eavesdropping. On occasion, it can be something to do with informants. But we believe it has a lot to do with illegal activity by yes, right. Law enforcement is engaged in by violating someone's privacy.
It's scary.
And has nothing to do with specifically targeting illegal activity. They're just listening to everything and then pulling it up. Sex offenses are. Well, I guess that's what Yonet does now, but that's a topical area that I think readers always like to listen, read. Simply because I think they get to engage in voyeurism on what is considered a proper medium where they don't have to be embarrassed because it's not a dirty magazine somewhere, right? So you get to talk, but that's another type of case you can go and look for in the courtroom. Anything you want to say about that, Mr. Editor or Josh?
I'm gonna kill the recording. Thank you for your 2 hours.